Hello, everyone, and welcome to this week's episode of Legal Talk Tuesday. I'm Crystal I. Myers, Esquire, founder and principal attorney of B Bossy LLC, a boutique law firm with a primary focus on helping small businesses, small brands, and small nonprofit organizations with their legal needs. Before we get into this week's topic, let me remind you that nothing that I say or do in this video is with the intention of creating an attorney-client relationship with me and any of you. This video is solely for educational and informational purposes only. Now, let's talk trademarks. Specifically, the trademark considerations you should keep in mind when picking your brand name. Between clients, family, and friends, I'm often asked my opinion on potential brand names. I've also heard at least a half dozen stories over the past few weeks about brands facing a roadblock in their business after discovering that another brand has the same name or a similar name. Now, I've said this before and I'll say it again. It is imperative that you do your research when choosing a brand name. Most people go for wording that is common or popular in their industry. Keep in mind, generic marks are not protectable because they are simply a common name for the product or service. Now, others choose names that are descriptive. Descriptive marks describe the particular good or service and are protectable after a showing of sufficient goodwill. If the name is merely descriptive, your level of protection will be weaker. However, if the name is distinctive, your level of protection is stronger. As a general rule, in order to strengthen your trademark protection, you should steer clear of popular, basic, simple words. You should also avoid words that present spelling challenges, that are so similar to another brand that it could cause confusion, words that are too technical that only experts in that industry would understand it, words that are not easily pronounced, words that limit you in growing your business, or words that frustrate customers. Choosing names that fit into this category can cost you money in rebranding your business, or it can devalue your business altogether and then force you to rebrand in order to gain notoriety and become successful. Believe it or not, you can strengthen your level of trademark protection by choosing a name that is memorable, that stands out, that's clever, creative, or even made up words. From a legal perspective, names that are fanciful, arbitrary, and suggestive have the strongest protection. This is because these marks are typically considered distinctive enough to receive trademark registration on their own. Fanciful trademarks are marks which are typically made up and only have meaning when applied to a good or service. The words themselves have no meaning other than to indicate a particular brand. Arbitrary marks are marks which have meaning, but as applied to a particular good or service, the meaning is unrelated. Finally, suggestive marks suggest some character or quality of the good or service, but do not describe the good or service itself. They require some form of imagination on behalf of the consumer to associate the mark with the good or service. Remember, the goal in naming your business is to help consumers distinguish one product or service from another by acting as a source identifier. If you are working on branding or rebranding your business and want to understand more about the legal aspects of naming your business, head over to my website, www.thebossy.approach.com, and book a legal assessment call with me. You can also learn more about me and the services that I offer on my website. While you're there, be sure to click on the Bossy Shop tab where you can find our Bossy inspired merchandise. Well, that'll do it for this week's episode. Until next Tuesday, be bold, be brave, be bossy. See ya.